Hello, my name is Marie-Èveline Touma, and the case at bar is Descôteaux et al. Versus Mierzwinski. The legal question can be formulated as follows. Did Mr. Ledoux's application for legal aid fall within the scope of solicitor-client privilege? The relevant rules of law concern the concepts of confidentiality as well as privilege. According to the authors of the book, these two concepts are to be differentiated. The court, however, seems to use the two interchangeably, which, as I said, the authors disagree with. Solicitor-client privilege includes an evidentiary rule as well as a substantive one. According to the evidentiary rule, a privileged communication cannot be tendered as evidence in court. As such, a justice of the peace has no jurisdiction to issue a search warrant for such a communication. The substantive rule is much newer. It was established by the Supreme Court in the Solosky case, though it was not explicitly formulated. The court formulates it in the case at bar in 4 points, which could be summarized by saying that whenever there is a conflict between a legitimate right and the right to confidentiality, the conflict should be resolved in favor of protecting the right to confidentiality. And any interference with the right to confidentiality needs to be limited to what is absolutely necessary for the purposes of the enabling legislation. Now, what is a privileged communication? Any communication made in order to obtain legal advice from a lawyer in the ordinary scope of their professional employment. This includes communications made either directly between a client and their solicitor or between agents of the client and agents of the solicitor. And this also applies whether or not the legal advice is ever given, whether or not the solicitor-client relationship is ever established. What's important is the intent of the communication. If the intent of the communication is to obtain legal advice, then the communication is privileged whether or not legal advice was ever given. There are exceptions to this rule, one of which is known as the crime-fraud exception. If I communicate with a lawyer in order to obtain legal advice, but for the purposes of better committing a crime, or if the communication itself is a crime, then these communications do not benefit from solicitor-client privilege because the furtherance of a criminal purpose fall outside of the ordinary scope of a lawyer's professional employment. Now let's take a look at the facts of the case to align them with the rules of law. Monsieur Ledoux applied for legal aid at le Centre Communautaire Juridique de Montréal. Allegedly, when he filled out the application, he lied about his financial situation in order to be admissible to legal aid. In Canada, this is a crime. A justice of the peace issued a search warrant for this application and for other documents pertaining to the case. The documents were seized and placed in a sealed envelope. There was a motion presented to the Superior Court requesting the quashing of the search warrant and requesting that the sealed envelopes be returned. The Superior Court dismissed the motion on the ground that since the application was communicated before any formal solicitor-client relationship was established, it could not benefit from solicitor-client privilege. However, the court did amend the search warrant to strike the words "and other documents concerning the case." The Superior Court erred. As we said, any information given with the intent of establishing a solicitor-client relationship is privileged. The justifications for this are the same as the justifications for the privilege itself. If, for example, I have a problem with somebody and I would like to speak to a lawyer to know A, if I have a case, and B, if they would like to represent me. For the lawyer to know whether or not I have a case, I need to give them a certain amount of information. And if I'm not confident that our conversation is confidential, I very well may omit crucial information. And this might lead the lawyer to give me legal advice, which is not the best legal advice. Similarly, for B, for the lawyer to know whether or not they can represent me, they need to know certain information, such as if I have financial capacity to pay them. This is sensitive information, and for me to be open with this lawyer, I need to be confident that our conversation is confidential. And therefore, these exchanges before the establishment of a solicitor-client relationship are just as important and need to be protected and are protected just as much as conversations had once the relationship is formalized. For this reason, the application of Monsieur Ledoux, the fact that it was of an administrative nature, that it concerned his financial situation, the fact that he may have given it to an administrative staff instead of directly to the lawyer, and the fact that it was given before any formal solicitor-client relationship was established, these do not affect the privileged nature of the form of the communication. Rather, it's the fact that Monsieur Ledoux lied on his application. And the fact that lying on a legal aid application, lying about one's financial situation in order to obtain legal aid, the fact that that's a crime, and the fact that he committed this crime, and the fact that that application is the material element of the crime, that's what renders that application outside the scope of solicitor-client privilege. It's worth noting that the Superior Court amended the search warrant to strike the words "and other documents concerning this case." It's interesting because this falls exactly within the substantive rule formulated by the Supreme Court in the case at bar. Yes, the application lost its privileged nature the moment Monsieur Ledoux lied on it. But the application also included, for example, lawyer notes on the back. Those remain privileged. The whole idea of the substantive rule is that if we are to interfere with the right to confidentiality, we need to do so as minimally as possible and keep it to what is absolutely necessary. And that's what striking the words "and other documents," that's what that does. We're not going on a fishing expedition. We're not looking at other documents. We can only look at what is an exception to the rule, and that is where Monsieur Ledoux lied about his financial situation. That's a crime. That's the exception. That's what we can look at. Anything else, even on the same document, it's got to be blocked out. That remains privileged. In conclusion, the legal aid application did not benefit from solicitor-client privilege, not because it was communicated before a solicitor-client relationship was established, but rather because it was the material element of a crime. Thank you.